My name is Michael Kang, and I teach here at the law school, and it's my honor to follow up on Charles Fried's keynote address and introduce my very distinguished panel here on the subject of the Roberts Court as the overturning court, question mark, the politics of the U.S. Supreme Court under Chief Justice Roberts. My own personal academic background is split between law and political science, and it's actually a combination that is common to, I think, every member of the panel, and I think particularly apt for the study of judicial politics, the politics of law. And as Charles Fried's address this morning has already sort of touched on, political science and law have at least traditionally approached judicial politics from what have been fairly distinct perspectives that, once you put together, might give us particularly nice leverage on the important questions of the symposium. So political science, on the one hand, traditionally viewed judicial decision-making as driven primarily, sometimes exclusively, by judges' political preferences, generally unconstrained by law and legal reasoning, while, on the other hand, legal scholars have tended to view judges as driven, in the important part at least, by law and legal reasoning rather than by raw political preferences. So there's been a tension between those two schools. I think it's fair to say, though, that more recently academics from both sides of that split have taken better and fuller advantage of the insights of the other side. And I think our panel today, with their combined training and expertise in law and political science, will really help us figure some of these problems out. So what I'd like to do is give you a very brief introduction to my distinguished colleagues here before getting straight into what I know will be very important and interesting insights from them. So going from your right to your left, first sitting right here is Professor Lee Epstein, who is a Henry Wade Rogers Professor at Northwestern University. That's a university-wide chair. She's also a fellow of the American Academy of the Arts and Sciences. She is, I think, the leading political scientist on judicial politics, the author of more than 100 articles and 14 books, including The Choices Justices Make, which won the Pritchett Award for the best book on law and courts. She's also, we're very proud to say, at Emory University, a double alum of Emory University, both her undergraduate degree and her PhD. Sitting to Professor Epstein's right is Professor Nate Persily, who is the Charles Keller Beekman Professor of Law and Political Science at Columbia and Director of the Center for Law and Politics at Columbia. He holds a PhD from Berkeley in political science. He's written extensively on pretty much every subject in election law, but particularly about political parties and redistricting. And toward the latter, he has actually served as a court-appointed expert drawing up legislative plans in Maryland, New York, and in this state of Georgia. And in fact, whenever I talk to Nate, he expresses apprehension about returning to Georgia for fear of the scary, lurking state legislator who will wreak some sort of havoc on Nate's life for revenge from the last redistricting cycle. Sitting to Professor Persily's right is Professor Rick Hazen, who is the William Hannon Distinguished Professor of Law at Loyola Law School in LA. He's a nationally recognized expert in election law, and particularly in campaign finance regulation, and the co-author of one of the leading case books on election law. He's the author of more than 50 articles on election law, and he's probably most prominently seen all over the newspapers and the media, at least in part because he runs the election law blog, which is an indispensable resource to all of us in the election law field. He's currently visiting at UC Irvine Law School. And then finally, Professor Guy Charles, sitting at the end of the panel, completes the panel. He is Professor of Law at Duke Law School and the Director of the Duke Law Center on Law, Race, and Politics. He's a leading expert on all things election law, but particularly race, voting rights, and redistricting. He joined Duke after serving as the Bennett Professor of Law at the University of Minnesota Law School and served an interesting stint there as interim co-dean for a little bit. He is the co-founder of the Colored Demos blog, and he serves as co-editor with me on a book series with Cambridge University Press on election law. And so that's the panel, and it's a great panel, and I invite Professor Epstein to start us off.
Thank you. Thanks so much, Michael. I can't help it. I have to just take a minute to respond to Professor Fried. Now, with all due respect, I don't know if Congress is passing more pro-business laws or not. I'm not sure, as an empirical matter. But the fact of it is, I think, even if they were passing more pro-business laws, the effect should work in precisely the opposite way that you say. Because what would happen is only the really good suits would go forward, because it would be harder to move up. And so actually the court should, I think on your logic, the court should be making more anti-business decisions. But that's not what we see. So that's my 1 second response, and I'm sure there'll be time for you to respond to my response. But that's not why I'm here. Originally, I have to say, I think I was on the scheduled to be on the final panel of the day, but the students asked me to move to this one because they were interested in some data that Andrew Martin, up there, Andrew Martin and I supplied to the New York Times. The data covered an aspect of judicial restraint, which is the reluctance to invalidate legislative action, and specifically overturnings of federal, state, and local laws between '69 and 2009. I'm very happy to oblige the students, though I think my punchline at the end of this is going to be that the Roberts Court really doesn't look very much different than the two courts it preceded, the Burger Court and the Rehnquist Court. I do think some of these data are informative and interesting. Okay. Let me start, though, with something I don't think is particularly interesting and informative in this debate. And that's a graph that looks like this. Okay? This is a very common graph that you see on some blogs, in journalistic commentary. And what it's showing to you, I'm sorry, I should have brought slides. What it's showing is the fraction of times that a justice is in the majority when the court votes to strike or invalidate a law, okay? And you see this kind of stuff all the time, and people use these charts to talk about, they'll say, oh, look, Rehnquist, he is a restrainist, and at the bottom, people like Marshall and Brennan, well, they're kind of activist, aggressive justices. There are actually a number of problems that political scientists have pointed out with graphs like this, and let me just mention two. One is you probably just don't want to look at the fraction of strikes when the court strikes. What you want to do is look at the fraction the justice votes to strike in all cases in which the court considers the constitutionality of legislation. And that will really help distinguish between the kind of aggressive justices and the meeker justices. But even that, you just don't want to look at those fractions and infer a lot about overturnings and judicial restraint. You want to consider other factors that may explain those fractions. Now, the thing that political scientists tend to focus on, of course, is ideology. And what they'll say is that, justices really aren't restrainist or activist in the sense of overturning laws. What they are ideologues, such that, liberal-leaning justices will tend to vote to strike laws in which the substantive policy content is conservative. Put simply, liberal justices will vote to strike conservative laws. Conservative justices will vote to strike liberal laws. And you need to take that into account. So putting these two things together, alternative explanations like ideology. Okay. Putting those two things together, you're going to get charts that look like this. And this is for all justices serving since 1969. So what I've got here is the justice confronts a conservative law. What do they do? Well, it looks on this graph like Alito and Rehnquist are the real restrainist, and Douglas and Marshall much more aggressive when it comes to conservative law. Well, flip over, now we've got a conservative law, a liberal law, and it looks like the liberals are the restrainist and the Alitos and the Scalias and the Thomas and so forth are the really aggressive justices. You put these two things together, and there's a very distinctive pattern here, one that suggests this ideological explanation has some purchase. And in fact, the ideological explanation holds for all of the 21 justices up here except for 3, Harlan, O'Connor, and Kennedy. Okay. So this is more informative than looking at the simple chart, but it still isn't sufficient. We still don't want to necessarily make claims about overturnings based on this, because all this is doing is accounting for ideology. There may be other factors that lead justices to strike or uphold laws. It could be something in the case selection process. It could be something about the nature of the federal law. It could be something about the political environment. So what Andrew and I did is we took a lot of the data that we had supplied for the New York Times, and we did some more sophisticated statistical analysis. The first thing we did was look at all of the justices' votes combined to strike or uphold, and did some fancy modeling. But the bottom line is, frankly, it's very hard to wash out the effect of ideology, that is, the effect of liberal justices striking conservative laws and conservative justices striking liberal laws. Here is an example of our results. Work? Yeah. This is when the justices are reviewing a conservative law. This is the justices' ideology on the bottom here. Most conservative justices over here, most liberal justices over here, and this is the probability that they're going to strike the law. This will work better? Yeah, probability of striking the law. So what you see here, and this combines all of the justices from 1969 to 2009, what you see is the conservative justices very reluctant to strike conservative laws, no such reluctance on the part of the liberal justices. And this takes into account lots and lots of things. You see exactly the same thing on the other side. You see the liberal justices over here, very reluctant to strike liberal laws. Conservative justices up here, much more willing to do so. Put the two together. They look a little different, but the plots are basically telling us the same thing. I should tell you that this holds. It holds for the Burger Court. That's the Burger Court reviewing a liberal law. The liberal justices, very willing to uphold. The conservative justices very willing to strike. It holds for the Rehnquist Court here, and it holds for the Roberts Court as well. Okay. The other interesting thing is we looked at all the individual justices. We see exactly the same patterns for the individual justices controlling for lots of other factors. In all but 3 of the justices, we see these patterns. Again, Harlan, Kennedy, and O'Connor. Now, you might say the fact that Kennedy doesn't fit the pattern is pretty serious, because on this current court, as we know, Kennedy is the center justice, and that would suggest that the ideological patterns may not hold on the whole. The interesting thing about Kennedy is over his career, the ideological patterns don't hold. But if you look at his behavior on the Roberts Court, that is 2005 to present, they hold. So for example, let's take a look at this. This is Breyer and Roberts. The blue is when there's a liberal law, and the red is when there is a conservative law. So you see Breyer is very unwilling to strike liberal laws, only in about 1 out of 10 cases, but very willing to strike conservative laws. The reverse, of course, holds for Roberts. Put Kennedy in. His pattern it's not as extreme as Roberts, but it's still a significant ideological pattern there for the Roberts Court. So at the end of the day, I think we have some more work to do here, but what we found so far is that there is a significant ideological pattern to upholding, to overturning federal, state, and local laws, and the Roberts Court is not excluded from that pattern. Thank you.
Mike took away my introduction a little bit, which is every time I do come to Atlanta, I am looking over my shoulder. The last time I was here, there was the federal court seized a part of the state capitol for me to work in, and we had U.S. Marshals stationed out there for fear that state legislators would peek in and see what the redistricting plan was looking like. So the current, so if you like your current state legislatures, you're welcome. If you hate them, I had to do it. So it was an amazing experience, traumatic. I am balder as a result of it. But now, one thing about redistricting is, you get a 10-year hiatus, and now we're in the thick of it again. So maybe I'll see you soon. So let me talk a little bit about the Roberts Court, and I think I'll stick really right to the topic of whether it's the overturning court, but in two ways. I want to talk a little bit about activism and the Roberts Court, and then also about a sort of current debate that's going on among law professors as to how far out of step the Roberts Court or other courts have been with American public opinion. So I've done a lot of work on polling data and survey data on Americans' perceptions of different constitutional controversies. I have a book called Public Opinion and Constitutional Controversy, available from Amazon. They're used copies, which means my family members have been selling them. And I want to look at sort of American public opinion on some of the issues that the Roberts Court has considered and talk just briefly about it. And then I'll end by talking about three of the sort of upcoming controversies, the health care challenge, the Voting Rights Act, and same-sex marriage. So let me start with the admonition or the admission that we are all activists now, right? That at some point we really have, I think, left in the dust the idea that some of the sort of Frankfurterian idea that activism or restraint as a judicial value should be applied across the board. And so it is remarkable to me when you watch judicial confirmation hearings to hear the way that activism is talked about by senators. My favorite example is, I believe it was during Chief Justice Roberts' confirmation hearing, where one of the senators says, in talking about Kelo versus New London, the case dealing with taking of private property in Connecticut, do you believe how activist this decision is? They allowed the city of New London to take the private property of this private individual. Right? So that activism now becomes the repository for all kinds of gripes, whereas used to be the argument was that a restrained judge simply deferred to the political branches. Right? So there's something like a taking of private property. Kelo is, if anything, a restrained opinion, which then produced all kinds of legislative responses. But we are all activists now, and I think all the members of the court are activists, and so we should sort of put that to one side and ask the question, well, they're activists toward what ends? What kind of activism is there? Now the caricature of the activism of both wings of the current court and recent courts is that you have the liberal activists sort of channeling the Warren Court, who are now sort of activists on behalf of racial minorities, gays, people seeking abortion, criminal and terrorism defendants and suspects, whereas the conservatives are protecting and are activists on behalf of corporations, gun owners, whites, Christians, or state governments. Right? You look at the types of laws that are struck down, and then the way the media will portray this type of activism, and it's sort of almost a representational model in who they see these justices as representing when they're striking down these laws. So the more interesting question is, well, what if you had to define the contours of the activism of these wings, what would it be? Now, there's been so much talk since the Warren Court about sort of the essence of liberal judicial activism that I won't spend much time on that, but the John Hart Ely's book plus sort of development since then about the liberal activists sort of acting on behalf of discrete and insular minorities on the one hand and opening the channels of political change, the so-called Caroline Products footnotes justifications. That was a way of explaining a whole set, not all, but a whole set of liberal reasons for overturning state and federal laws. You could get a lot of the minority protecting decisions of the Warrens Court by reference to those justifications. You could get a lot of the sort of protecting of dissenting voices, the one-person, one-vote cases, et cetera. Might not be able to get Roe versus Wade, as John Hart Ely would admit, but you got a lot of what was considered to be liberal judicial activism by pointing to those kinds of justifications, protecting discrete and insular minorities, freeing the channels of political change. But what about conservative judicial activism, right? So long as you don't take that caricatured vision of sort of the court representing particular interests, what are the different descriptors for the Roberts Court's brand of judicial activism? And here, let's sort of admit something that is evident from Lee Epstein's data and others, which is, there's the Roberts Court and then there's the Roberts Court, right? Is the Roberts Court really about Chief Justice Roberts, or is it really the Kennedy Court now? And was the Rehnquist Court really about Rehnquist? And there's a diversity of decisions that come out in these courts, some liberal, some conservative, right? And so when we talk about these courts by reference to the Chief Justice, we're necessarily eliding some of the great complexity that is in there. But what about the Roberts Court decisions? And here I want to just mention sort of the most salient cases. And I think one of the challenges when you deal with some of the data that Lee Epstein put up there is sort of, are all overrulings created equal? Right? Can I trade you a Citizens United for 2 Stenberg versus Carhartts? Or, what is it that, do you have to sort of have some measure for the size and the impact of a ruling in order to then evaluate the significance of a decision in terms of the court's overruling of either prior precedent or of a particular piece of legislation, right? So that if the court does actually upend the health care law, that we should probably give, a bigger number to than if they were overturning, a small taking of private property in New London, let's say. Okay. So what are some of those? What are some of the cases I just want to reference, just so we're all on the same page? So Citizens United I want to talk about both because it's in my wheelhouse and I study campaign finance, but also because it's the case that seems to undergird a lot of what's discussed on this panel. But also there are cases dealing with race, the parents involved case dealing with desegregation, the Voting Rights Act case, Northwest Austin Municipal Utility District number 1, otherwise known as NMUDNO, in which they called into question the constitutionality of the Voting Rights Act. The Ritchie case, which itself is a statutory interpretation case but has sort of importance as, I think, a window onto the Roberts Court and Justice Kennedy's views on race. I want to talk also about Heller, the Second Amendment case where the Supreme Court struck down and later reaffirmed its view about the unconstitutionality of certain bans on gun possession. And then 1 or 2 other cases that are sort of below the radar screen. Let me start by saying, and I think this might echo a little bit of what Charles Fried was saying in talking about campaign finance, that you can find in some of these Roberts Court cases a Caroline Products kind of justification for the reasons for overruling, okay? And while Citizens United has been portrayed as this case where they're basically delivering to General Motors or Microsoft or other big corporations this sort of unchecked power to dominate American politics, for me, the strangest thing about Citizens United is why it was not a 9-0 decision, actually, in result, at least, on behalf of Citizens United. This was a nonprofit ideological corporation that was putting up putting up a movie that on sort of on-demand programming that was available. The viewers wanted to see it over the television, right? It wasn't your typical kind of in-your-face TV ad. So if the First Amendment means anything, it probably means a nonprofit ideological corporation can make its views available to those who might want to hear that Hillary Clinton is a socialist, right, or that she's destroying America, which was that was the argument there. Now, just because you believe that doesn't mean then, all right, well then the typical sort of General Motors ad or you know, that Microsoft ought to be able to spend $1 billion on an advertisement in the heat of an election. But if you listen to the oral argument in Citizens United, and for that matter, the written opinion, part of what they are trying to point to is that most things that are incorporated entities, right, do occupy a space which is comparable to typical private associations. Now, they didn't have to go as far as they did, right? And there were 900 ways they could have limited it to these kinds of groups, right? Your kind of typical ideological groups. But that is who is at issue in Citizens United. And the way that Kennedy talks about it is in the typical language of freeing the channels of political change, of trying to protect certain voices, right? And it is animated by a fear that a lot of the conservatives have had on the court about campaign finance reform, in particular, having a bias in favor of incumbents and the parties that write the laws. Now, again, they didn't have to, we could think of 9 other ways that they could have written that decision, but one way to justify the activism in that case, and it is an activist decision, is to look at the actual institution that was involved and the reasons that they think that institution was deserving of protection. So there is this kind of Caroline Products activism that is a part of the Roberts Court. There's another, which is what might be called originalist activism, and the Heller case is most emblematic of that. Both in the majority and the dissent seem to buy into a lot of originalist thinking in these cases, so that previously, you know, the argument for judicial intervention that you get from the Caroline Products footnote, John Hart Eliot, et cetera, is that you worry about certain groups that don't have power in the political process being able to get protection from judges. Here, the argument is that a law like this, banning handguns, it sort of runs afoul of some fundamental understanding about what the Second Amendment is about. Now, that kind of originalist activism is actually kind of rare, I think, in American constitutional law, striking down a law on those bases, right? Part of it is because we've never really had an originalist majority on the Supreme Court in the vein of, say, Justice Thomas and Justice Scalia, right? If you remember, and Chief Justice Roberts doesn't himself in his confirmation hearings describe himself as an originalist. He says he's kind of a pluralist. He takes from many different areas. But Heller, if it's a sign of things to come, speaks to this idea of originalist activism. A third core of activism in the Roberts Court is what I think Pam Carlin has said this, and I know someone has, what she calls counter-majoritarianism, okay? So the counter-majoritarian difficulty, right, is been written about ad nauseum. I almost hesitate to even utter it more because it adds to more print on the topic. But the idea being, well, what special justification should judges have in order to strike down laws that are supported by the majority? And there are a series of cases, if you look at the Roberts Court, where legislation that was passed in order to secure rights for minorities, let's say like the Voting Rights Act, like Title VII, is then being checked by the Roberts Court, right, as going too far. And so the cases that fall into line there would be parents involved. That's the school desegregation case, Ritchie on the one hand. The Voting Rights Act case, which I think is sort of a dead man walking in a lot of the Voting Rights Act, Section 5 of the Voting Rights Act, which will probably be slowly chipped away by the Roberts Court. And what is the sort of genesis or the root of some of this counter-majoritarianism, I find Justice Alito's opinions in some of these cases to be very revealing. He, in both the Christian Legal Society case, which dealt with the rights of a Christian student group at Hastings, in a public university in California, as well as his opinion in Ritchie, sort of give a window into his thinking about what is happening, that the sort of interest group politics that are coming to dominate and are undergirding some of, for example, the types of employee preferences that were at issue in Ritchie are something that needs to be checked, that they are fundamentally unfair. And while, in the end, these types of the laws are struck down on behalf of, in the case of Ritchie, white firefighters, in the case of Christian Legal Society, although the court doesn't go this way, it would have been for the sort of evangelical student groups, that there is something that Justice Alito has been paying attention to, which is some kind of sort of power grab by interest groups over sort of local jurisdictions. And then finally, there's what might be called activism in pursuit of tradition, right? That there's something about certain laws that are untraditional and aberrant, and that tradition needs to be restored. Section 5 of the Voting Rights Act, I think, is a case like that. And so the Namudno case, where the court expresses, 8 justices, that it's hard to justify the current coverage formula of Section 5 of the Voting Rights Act, suggests that several of them think that that type of aberrant form of lawmaking is sort of ripe for reconsideration, and the fact that the Congress has failed to reconsider it presents a constitutional problem. All right, now let me just move on to, is the Roberts Court out of step with public opinion, or if it is, in what settings? Let me say, first of all, you shouldn't necessarily care about this. And I know they don't. And so it's not like they will all, or at least they will say they don't, right? Which is that public opinion polling is a art and a science, and justices in the Supreme Court will frequently say, well, that's not our job, we shouldn't be paying attention to it. But we're academics, so we can. And so there's been a lot of writing recently about public opinion and the courts. Barry Friedman's book, Will of the People, makes the argument that the court rarely can step out of line with the public for very long. That's not an original thought. Bob Dahl had said that long ago. Jeffrey Rosen has a book on it. All of them completely miss the point, I think, and it goes back to the same question I said before, which is, well, look, the court is sometimes out of step with public opinion, but the real interesting question is when, right? What types of areas of constitutional law should we expect, and maybe do we want to expect the court to be against the grain of American public opinion? And so if you look at the Roberts Court's decisions in Heller, Ritchie, parents involved, at least the conservative results in some of the terrorism cases, right? And some of the more liberal death penalty decisions, as well as their opinion in Carhart, the late-term abortion case, they are right where the American public is. The American public is very close to where the Roberts Court is on those cases. Where the court has departed from American public opinion is in the First Amendment area, right? And so Citizens United is there's no matter how you ask the question, the court is out of step with the American public when it comes to protecting the rights of corporations to advertise in an election. All right? And you would say the same thing about this case, U.S. versus Stevens, which they handed down, which was all about whether depictions of animal cruelty, like dogfighting or these sort of videos where animals are tortured, that was banned by federal law, and the court struck that down as overbroad. And public opinion polling shows, of course, that how many Americans are in favor of the right of someone to go sell videos where animals are tortured, right? That's an easy public opinion survey. But the First Amendment has always been an area where the court has been out of step with the American public, right? Whether you're talking about their flag burning decisions or any other area where they are rights protective for dissident speakers, right? Those are the cases that end up coming to the court. And the fact that the Roberts Court has been out of step with the public on First Amendment cases is not terribly surprising. So let me just end with what to look forward to with the Roberts Court, and I'll just leave it hanging there, and maybe we can talk about it in the question and answer, which is the same-sex marriage case that's percolating, the health care challenges, and then the Voting Rights Act. So as you know, the challenge to Proposition 8 is now, from California, is now working its way through the Ninth Circuit, which will hand down its decision sometime this year, and then probably go on bank, and then it'll eventually go to the Supreme Court. The court will be receiving this case at a time when America will be almost exactly balanced on the issue of legalization of same-sex marriage. There is a steady trajectory upward where over 40% now are in favor of legalization of same-sex marriage, but even by the time that they get it, it might be closer to 50%. And so who is going to win the day on same-sex marriage? Is it going to be sort of those who have been advocating for a kind of Caroline Products rationale? You see it in the gay rights decisions of Justice Kennedy dealing with Lawrence, Romer, et cetera. Or are they going to sort of leave this for another day until until maybe public opinion has come around even further? On the health care law, we have we have 4 decisions, two going one way, 2 going the other, I think. That, if you had to sort of handicap it, if the Supreme Court is willing to strike down the individual mandate or to strike down the law in greater detail, then that is much more than Citizens United. I tend to think we're getting very close to Lochner era if that's where the court is going. However, the country is completely divided on the constitutionality of the health care law and whether the Supreme Court and the other lower courts should let it stand. And then finally, on the Voting Rights Act, I tend to think the voting rights, that the best casualty of Citizens United is the Voting Rights Act. And by that I mean it makes it more likely that the Supreme Court is going to end up acting very incrementally when it strikes down the Voting Rights Act. It's clear that there's a majority that's very uncomfortable with Section 5 of the Voting Rights Act, and there are lots of different ways that they're going to target it. But because of the flack, and I should say the surprising amount of flack that they got after Citizens United, which, based on the series of campaign finance decisions, was actually a small incremental step for the Roberts Court. But the surprising amount of flack that they got both in the State of the Union and in American public opinion, I think they're going to walk more gingerly in the area of election law, and so that maybe the Voting Rights Act sort of will live to see another day, or at least will be sort of slowly whittled away as opposed to being sort of clubbed with an axe. So that's where I see things going, and that's where I see the Roberts Court to have come. Maybe I'll see you all during this redistricting cycle sometime over the next year, but if not, I'll be happy with that also. Thanks.
Thanks, Nate. And now Professor Rick Hazen.
Thanks very much. And I was just so thrilled and honored when Michael Kang and the Emory Law Journal invited me to come speak today. And then when they told me they wanted me to speak on Citizens United, my heart sank because it's basically all I've been doing for the last year. And so I thought, what can I say about the Roberts Court as an overruling court without mentioning Citizens United? So I'll briefly mention Citizens United, then move on. If you read the New York Times editorial page, you think that the Roberts Court is the huge overruling court, and Citizens United is the case that shows it. In fact, I'm not so sure, and I think from the other panelists and from other evidence, it's not clear at all that, generally speaking, the Roberts Court is more of an overruling court than any other court. And what I wanted to talk about are other ways in which Supreme Court justices try to move the law besides express overruling. And it seems to me that we can measure overrulings. The court says that a law of Congress is unconstitutional, the court reverses prior precedent. We can measure that. But there's a lot more subtlety in terms of what justices do. And so I wanted to walk through some of that and talk about when a justice wants to move the law, what are the different ways to do it, besides express overruling. So I come to this not as the first person to think about this. Nate mentioned Barry Friedman. Barry Friedman at NYU recently wrote a law review article that was in the Georgetown Law Journal where he talked about stealth overruling. And the idea here is that sometimes rather than expressly come out and say this old case is overruled, the court will do so in a way that, as Friedman puts it, is a stealth overruling that either fails to extend precedent to the conclusion mandated by its rationale or reduces precedent to nothing. And the example he gives here is the Miranda rule, which we all know about as an important criminal procedure protection. He says if you look at the modern Roberts Court cases, it turns out that there's not much left of Miranda, but the public doesn't know it because the court's never come out and expressly said, as it did in Citizens United, we're overturning a precedent. Friedman is very critical of stealth overruling. He says it obscures the path of constitutional law from public view, allowing the court to alter constitutional meaning without public supervision. Now, it's not clear that the Roberts Court does this more than any other courts have done this. I think go back to Baker versus Carr, one of the most important opinions come in the 1960s, in which we could say that there was a stealth overruling of earlier precedent. It used to be that redistricting cases were not justiciable, and then they became justiciable. And I don't know that we can call the Roberts Court more activist than any other court. It might be that the sets of Supreme Court justices are equally activists. It's just a question of whether the law deviates more from their ideal positions. That is, if the law is in line with what you think is the right law, you'd see less overturning. So I want to look at 4 other ways in which the justices can move the law. I call these anticipatory overrulings, invitations, time bombs, and inadvertence. I'm going to give you examples of each one and then briefly compare them. Nate made reference to the Namudno case. The Namudno case was a very interesting case in which the Supreme Court was faced with the question whether this longstanding law, part of the Voting Rights Act, that says that certain jurisdictions that have a history of discrimination need to get permission or preclearance before they make changes in their laws. They have to get permission from the U.S. Department of Justice or from a court. In the Namudno case, the argument was that this law is no longer justified. There's no longer evidence that these jurisdictions, primarily in the South, are still engaged in discrimination. Why should it be that every time you move a polling place across the street or enact a redistricting plan or pass a voter ID law that you have to get federal permission? The Supreme Court did not expressly overturn the Voting Rights Act. It didn't do something bold as in Citizens United. Instead, the court engaged in what I've elsewhere described as a completely unjustifiable act of statutory interpretation to avoid answering the constitutional question. On an 8-to-1 vote, the Supreme Court said, we're not going to reach the constitutional question, we're just going to leave it for another day. But along the way, the court did what I call an anticipatory overruling. It gave all of the reasons why the court is poised to overturn the Voting Rights Act, this portion of the Voting Rights Act, without actually doing it. So this is an anticipatory overruling. It says to the Congress and to the public, be on guard. There is change that is potentially coming. This case could be overruled. And I'll talk about why to use each of these tools as I go on. A more subtle way of than anticipatory overrulings in terms of trying to change the law is invitations. Justices can invite litigants or invite Congress to take action in their opinions. And so in one of the cases decided before the Citizens United case, another campaign finance case called Wisconsin Right to Life 2, Justice Alito issued a separate concurring opinion that was 1 paragraph long. And in that 1 paragraph, he invited litigants to bring further challenges in the event that they saw continued constitutional problems. Now, of course, everybody knows that you can bring a challenge to a constitutional law anytime, to a constitutional precedent anytime you don't like it. Why would Justice Alito go out of his way? Well, this is a way to try and shape the docket to signal to litigants that here's an issue that I would like to be reconsidered. And in fact, Justice Alito has done this consistently. While he's been on the court, he has consistently pointed out that he wants briefing an argument about stare decisis, about respect for precedent, when he should overturn precedent. And that's probably the most likely reason why Citizens United was set for re-argument for briefing on the very question of whether those old precedents should be overturned. He seems ready for overturning precedent, but he wants full briefing. So he is inviting litigants to bring more cases. So this is a way to shape the court's docket and to change the law. Justice Ginsburg, who now on a more conservative court, she being one of the more liberal justices, sits on the losing end of a lot of these cases, has been sending her invitations not to litigants to bring more cases, but to Congress to overturn the Supreme Court in statutory cases. So the most prominent example here, and Justice Ginsburg wrote about this recently in a Minnesota Law Review article. She's very forthright about it. In a dissent in the Ledbetter case, which dealt with how to deal with pay disparities under Title VII, she said the court's got it all wrong, and she said the ball is in Congress's court. And she invited Congress to overturn the statutory decision of the Supreme Court, and it was the very first thing that President Obama signed as president was an act by Congress overturning it. So you can invite the litigants to bring cases, or you can invite Congress to make a change. A third way to try and change the law is what I've referred to here as time bombs. This comes from a very interesting new biography of Justice Brennan, where there's a discussion in there in which Justice O'Connor is deciding whether or not to join an opinion of Justice Brennan, and we're told that Justice O'Connor had taken to heart Justice Powell's warning that Brennan planted little time bombs in his opinions. She learned to watch for these seemingly offhand throwaway phrases that were later exploited in cases. So here's another way to try and change the law very subtly. Put some dicta, put some throwaway lines, put some citations into your cases to try and plant the seed for the next case. And so here's a great example of this in a case that's currently before the Supreme Court. A couple of years ago, the Supreme Court decided a case called FEC versus Davis. In that case, it involved a portion of the McCain-Feingold law that allowed candidates who were running against millionaires to collect larger contributions, and the court said that was unconstitutional, it was an equality rationale, it violated the First Amendment. In the opinion written by Justice Alito, he has a discussion, and he has a C citation to an Eighth Circuit case involving an issue about whether or not public financing plans that give additional public financing when someone faces a wealthy opponent are unconstitutional. Well, now that very issue is before the Supreme Court in a case called McComish versus Bennett. The question is a public financing plan that gives extra public financing to someone facing a wealthy opponent, is that unconstitutional? And there's a debate, and you actually can look at the briefs, and there are citations, the law students will appreciate this, there are citations to the Blue Book, an argument over the signal C. What does that mean? And is that in fact, was Justice Alito in fact relying on this case, and does it have any precedential value? And so this is, I think, at least arguably a time bomb that Justice Alito put in the last opinion knowing that one of these cases is going to come down the pike. It's really hard to know when a justice is planting a time bomb or whether it's just inadvertent. Maybe a clerk just put that line in. Maybe Justice Alito didn't mean anything by it. We'd have to know something about the justice's intent. The final way that justice move the law, to me, this is the most interesting way, is that justice can move the law through error, through inadvertence. And this is really, I think, the most troubling of all of these, because in the first three examples I give, it looks like there's some calculation on the part of justices. So here's a great example. There's a case called eBay versus Merck Exchange. It was a patent case, and the question was whether the Federal Circuit, which had a rule that that said you could always get an injunction in a patent case if you can prove that there had been a patent infringement. The Supreme Court unsurprisingly said, no per se rule, judges have to use discretion. That was completely not a surprise. The court overturns the Federal Circuit on these kinds of things all the time. But what was a surprise was that Justice Thomas, for a unanimous court, wrote an opinion in which he says that we are going to apply the well-established principles of equity, and he set forth a four-part test for the application of permanent injunctions. The only problem with this, as remedy scholars all agree, was there was no familiar four-part test. The four-part test that Justice Thomas put forward, the first two elements are exactly the same, and the test not only had never been used, but it made a number of changes in the law, including moving the burden in terms of proving whether or not there's a public interest from the defendant to the plaintiff. So how did this happen? Doug Laycock, who's a remedies expert, went and traced it, and it looks like it was an error that was introduced in the district court opinion and copied by maybe a clerk or by Justice Thomas, who wrote the opinion, and then mangled a little bit more when it was translated, and so the law changed. And so that wasn't the law, but now it is the law. And so the case has been cited in this new standard has been applied, I think, in 1,600 lower court cases. The Supreme Court recently affirmed it as the traditional test in a case decided last year, the Monsanto versus Germain Seed case. And now everyone's struggling with trying to apply this test. So this is another way that justice moved the law. And I want to suggest, maybe we could avoid, not think about it if it's just random errors that come in any direction. But my supposition is that inadvertence is likely to move in the direction of the justice's ideology. And the reason is this: if a clerk puts something wrong, that's legally wrong in a draft opinion, the justice is looking at it, and it's not in line with the justice's ideology, the justice goes, oh, this isn't right, go fix that. But if it's in line, the justice must think, oh, that must be what the law is. And so inadvertence is going to tend to follow, I think, what the justices are. And if you look at where Justice Thomas is on injunctions, he has signed on or written a number of opinions in recent years where he's made it harder for plaintiffs to win injunctions, easier for defendants to get out of injunctions, to seek modifications of injunctions. And so even inadvertence is likely to move the law in particular directions. So if we think about this is probably too small for you to read, but if we think about the different ways that courts move the law, there are costs and benefits of each one. Express overruling tells everybody very clearly what the change in the law is, but as in Citizens United, it opens you up to potential criticism, public criticism, scholarly criticism. You could move to stealth overruling, which changes the law without incurring the public criticism. The disadvantage of that, besides that you get Professor Friedman condemning you in the pages of the Georgetown Law Journal, is that there's greater uncertainty. If there's stealth overruling, you still can have justices who are going to say Miranda remains good law and actually try to apply it. Anticipatory overrulings seem to be geared to Congress and the public. If you think again of the Namudno case, the idea is that you can avoid confrontation with the political branches if you don't actually come and overrule the law, and you can prepare the public for the eventual change that's coming. Rather than do it in one fell swoop, there's now a signal. So if the Supreme Court in the Shelby County case, which is working its way through the courts, ultimately strikes down the Voting Rights Act, and I think I'm going to disagree with Nate here and say that when that case gets to the court, I think it's pretty likely that it will overturn the Section 5 of the Voting Rights Act, and that could actually save health care, because it'd be hard to do Citizens United overturning the Voting Rights Act and health care within the same 5-year period. Maybe, we'll see. So the anticipatory overruling can let the public know that the Voting Rights Act is on borrowed time. Invitations to litigants, they're less direct, they're less powerful, but they still help set the agenda. You can help shape the docket, but it's less powerful. Invitations to Congress, well, why is it that Justice Ginsburg isn't sending invitations to Congress rather than to litigants? Well, she understands what the Civil Rights Bar understands. You want to keep everything you can out of the Roberts Court right now. So she's not trying to invite more cases. She's trying to invite Congress to overturn those cases that can be overturned. So if you're a justice holding a weaker hand, as Justice Ginsburg is right now, you go to Congress. Time bombs, they are even less direct. They might not have an effect. We have people arguing over what the C citation means, but they can fly under the radar, and then justices can feel bound in the short term. And of course, if you care about public opinion, you can say, well, this result follows from what we said in the earlier case, and the public is not going to be drawing fine lines between holdings and dicta and C citations and all of that. And finally, inadvertence. Inadvertence is troubling because if you may have different views about whether justice should change the law, but I think we all agree the law should not change if no justice wants it to change. And so this leads me to the recommendation that those of us who specialize in various fields, whether it's election law or remedies or whatever, need to watch what the Supreme Court is doing in various cases and try and help the court. Because nobody receives any benefit when the law moves inadvertently. And so in sum, if we're trying to think about whether the Roberts Court is an overturning court or whether any courts are overturning courts, the full picture requires looking more than at just those cases where they say, we hereby strike down or we hereby reverse. There's much more subtlety going on, and justices have a lot more in their arsenal than just overruling. Thanks very much.
Thanks, Rick. Now, Professor Guy Charles.
Thank you, Michael, and thank you to the editors of the symposium. So as the last person on the panel, I know that I have one task, which is to try to be brief because I'm holding you and the bathroom, I'm between you and the bathroom break. So I will try to do my best, and given the fact that a number of the previous people before the panel have addressed some of the questions that I want to talk about, it makes it a little bit easier for me to set up these particular issues. So I'll take off particularly where Rick and Nate left off. And part of the question that I want us to think through are what are the markers, how do we know when the court is behaving in a political way, or how do we know when it is behaving in a strategic way? And these obviously are difficult questions to ask, and in the tradition of great law professors, I will pose and do less in terms of answering. So let me pose it in the context where we all left off with Nemudno on one side. So you've heard a little bit about this Voting Rights Act case, Nemudno on one side, and Citizens United on the other side. So part of the question is whether the court will push as far as it can, for example, in a case like Citizens United, how worried is it of backlash? How well can it anticipate backlash? How well can it anticipate that the majoritarian process will react against what the court is doing? So as you know, Citizens United dealt with the constitutionality of a campaign finance provision prohibiting a corporation from using their general treasury funds to make independent expenditures, whereas in Nemudno you had a small utility district in Texas that was required to submit election-related changes to the DOJ or to the district court. Now, both cases presented a statutory interpretation challenge as well as a constitutional challenge. And in Citizens United, the statutory interpretation challenge was whether the statute at issue applied to a corporation such as CU. Nate was talking about that earlier. You've got a nonprofit corporation. It's issue and ideologically driven. It receives a small portions of funds from for-profit corporations. And it wanted to release a movie by making it available through video on-demand distribution. And part of the question was, well, can you use the statute to address the particular problem at issue? And of course, in Nemudno, the statutory interpretation question was whether the statute permitted the utility district to bail out. And in Citizens United, the constitutional issue was the application of the First Amendment to this campaign finance restriction. And in Nemudno, the constitutional question was whether Congress exceeded its constitutional power in requiring Nemudno to pre-clear. So what's interesting, of course, is that in Nemudno, the court decided the case on statutory grounds, and as Rick pointed out, went out of its way, in a tortured way, to decide on statutory grounds, but avoid the constitutional question. In Citizens United, I would argue that the court went out of its way to avoid deciding the case on statutory grounds in order to reach the constitutional question, right? So when we think about whether the court, how political the court is, in what ways is it behaving strategically, I think we also need to think through what are the things that regulate and put brakes on why the court decides to make the particular moves that it makes. Why, for example, in Nemudno, the court decided that this case was best dealt with on statutory interpretation grounds, even as Rick points out, it lays out specifically what the constitutional arguments are, right? So it's a perfect fake where the Chief Justice writes the opinion and says, here's the reason why this statute is unconstitutional, and by the way, instead of simply saying, therefore, it is unconstitutional, but we don't really need to address that question, so we're going to address it on statutory grounds. Whereas in Citizens United, at least from my perspective, the statutory analysis of the court is significantly less persuasive and provided the court with plenty of opportunities to decide the case on statutory grounds instead of torturing the statute to reach the constitutional issue, which is the opposite of what it did, tortured the statute in order not to reach the constitutional issue in Nemudno. So part of the question then has to be, what is going on, why reach the constitutional question in one case, but avoid it in the other, particularly where it seemed that in one case the constitutional question was better presented. In fact, Mudno was a strong constitutional challenge to the Voting Rights Act itself. There's some interesting hints that are provided in Citizens United by the Chief Justice in his concurring opinion, where he feels compelled to essentially address this particular question and says, look, we are not an activist court. In fact, let us demonstrate how we are not an activist court. And the Mudno, where we could have, in fact, struck down the Section 5 of the Voting Rights Act on constitutional grounds, because we found a relevant statutory hook, we were able to address that issue on statutory grounds. Whereas here in Citizens United, we are forced to. We actually have no choice but to reach the constitutional question, because that is the question that is at issue in Citizens United. That first pass by the Chief Justice I don't think is persuasive, because as I hinted out earlier, that I find the statutory analysis in both cases quite tortured. Then the Chief Justice also went on to say something to this effect, that look, where we can exercise restraint, we will, but where we can't, where the law requires us, where the Constitution requires us to do so, we can press on. And I quote specifically, when deciding whether to re-examine a prior erroneous holding, we must balance the importance of having a constitutional questions decided against the importance of having them decided right. Now, the question then is, does that present us with any clues as to when they're going to jump that line? Is it the case that in the Mudno that it was difficult to decide the constitutional question right? I don't think so, because in part the Chief Justice laid out precisely exactly how he would decide the constitutional question. But he does tell us that they won't be hesitant in deciding a constitutional question and overturning when they feel that really they can do it and they can get away with it. One way to read Roberts' concurrence is as a statement that stare decisis is important, but it's not necessarily going to bind us from overturning a prior precedent where we think and consistently think that the prior precedent needs to be overturned. That the concurrence indicates more of a longer view with respect to how the court might approach the question of overturning. So if you think about the fact that the conservative majority on the court, and as Lee Epstein's data points out, liberals, when they're in the majority in the court, will not shy away from challenging precedents that they disagree with, then there has to be some element that determines when it is that they're going to cross that bar. One way to think about Citizens United and the Mudno is the court's assumption that overturning Section 5 of the Voting Rights Act and Citizens United would have been an anti-majoritarian act that would have subjected it to strong public criticism and outcry, whereas on the other hand, overturning the provision at issue in Citizens United on the grounds that it violated the First Amendment would not have been an anti-majoritarian move, would have been a majoritarian move, and would probably sneak under the radar. But as Nate pointed out in his talk, it seems that the public opinion on both of those issues went the other way. Perhaps part of what is going on and what explains these particular cases is that the court guessed wrong as it was thinking through what the types of reaction would be to both of those cases. That Citizens United turned out to be a much stronger case in terms of public opinion and backlash than the court anticipated. And who knows how Section 5 of the Voting Rights Act will turn out, right? So when Rick and Nate and Lee, when we're all talking about how the court is going to approach the health care debate, how is the court going to approach same-sex marriage, it is not coincidental that the court's move towards greater protection for same-sex couples also mirrors the majoritarian public opinion moves and the public at large. It could be the case that in some areas, that majoritarian concerns might serve as a brake for regulating when the court is going to overturn a particular constitutional provision that ideologically it would want to do so. One could argue that if the court is afraid of some elements of backlash, even though we know that the majority of the public, the regular public, does not pay attention to Supreme Court decisions, but certainly certain types of issues resonate more with elites and with the media than other types of issues. And those types of issues might be in those areas that we see this majoritarian concern coming more into play. The guess from the court that campaign finance is very dry, boring, nobody cares about it type of an issue is not going to resonate with the larger public might have been mistaken because of the way then the issue was framed with respect to giving effect to corporations a greater role in the political process. So it may be the case that looking at particular areas and looking at the resonance and salience that those areas might have might help us to understand better the direction, might help us to understand and predict better the places in which the court might be, a majoritarian ideological position from the court might overturn a particular provision that it finds unconstitutional and might refrain, might engage in stealth overruling or might engage in anticipatory overruling depending upon the salience of the particular issue. Now, one has to think about and I want to end here with this practical question, is there a difference for practical purposes, among the various approaches that the court uses? So when you look at Namudno as an example, it seems that the message is fairly clear that Section 5 of the Voting Rights Act is on its last legs. Now, one might say that there is a fundamental difference between overruling, striking down Section 5 on constitutional grounds, as opposed to inverting its meaning on statutory grounds, and clearly that is the case. But the message that is being sent in both Citizens United, as well as in a case like Namudno, I think those messages are relatively clear. But I leave you with this. I think in order to understand what it means that the court is behaving politically, what it means that the court is behaving strategically, how to predict when certain cases like the healthcare debate might resonate with particular majorities on the Supreme Court, I think we need to have a better appreciation for the role that salience, majoritarianism, the way that these issues might play in elite publics, the role that these particular characteristics might affect the justices and have an impact on their propensity to overrule or to engage in particular types of other exercises of statutory interpretation that we might find more or less compelling. I will stop here.
So we have time for questions, and I'd invite you to approach the two microphones in the middle of the room with any questions you have. I might first, in the meantime, ask the panel whether they have any questions or comments for each other. Okay. Question right over here.
All right, yes. So, Nate, you mentioned that you don't think that there's a lot of pure originalism that goes on when judicial review occurs, at least on the current court. I'm curious what your thoughts are then about sovereign immunity jurisprudence and moments where the court has struck down congressional abrogation provisions, because that looks a whole lot like pure originalism. And then my second question very quickly is, what grade do you think John Hart Ely would give the Robert Court's approach to judicial review?
What grade would he give? Well, now I have to tell my John Hart Ely stories. I got to know him. He was at Stanford when I was a law student, but he then left to go to University of Miami because he was an avid scuba diver. And so he then left. It was very interesting. He taught my last semester at Stanford. He taught a class on underwater treasure, which I'm sure is not one of those sort of core curriculum classes at any of our law schools. But for a scuba diver, it made a lot of sense. But he I was editing an article of his in the Stanford Law Review, I remember, and I live in Miami, and so I went out and I was working with him. And this is totally irrelevant to your question, but he had a totem pole in his front yard. Does anybody know about this? With his face on it. And he had a face of him, his dog, an eagle, and a woman's face on it. And I said, "Who's that?" He said, "Well, that was the woman I was dating at the time, but now it's a generic woman." He said, and he, yeah, right. Well, we didn't want to take down the totem pole. So I'm sure he'd say the Roberts Court is wrong. I just don't know why. I think that, he would say that the Roberts Court is not, certainly not consistent with his theory of constitutional interpretation, but I think he would say that most courts have been wrong. But it depends on the case, of course, and what. Let me say about originalism more generally, it is very rare. The point is that there has not been an originalist majority on the court. Yes, in sovereign immunity and other cases, you're going to get all kinds of, people are going to pay attention to originalist arguments. The question is how determinative they are, and you really get nothing like what you have in Heller. Right? I mean, Heller is real. I mean, part of it is because it is, I would say, breaking new ground, and they're going so deep into the materials. But that level of investigation into the framers' intent is rare in a majority opinion. Right? I think that that's just empirically true. Part of it is because Justice Scalia and Justice Thomas, right, are not usually the ones who, they are the most strident originalists, and they're usually not ruling the day on these cases. But, so you don't see Roberts and Alito and Kennedy being the ones who are going to be pushing as hard on originalism as sort of a defining ideology to determine an individual case.
I want to ask a question to Lee. You pointed to a handful of justices who you said were not ideological, didn't fit into this pattern. I think you said Harlan, O'Connor, and earlier Kennedy. I don't know, maybe it delves into the world of psychoanalysis, but what do you think explains when a justice is not ideological? How could we get more of them? And what changes with Justice Kennedy, if you can say?
Well, I think I don't want to say much about Harlan because our data start in 1969, so we don't have a lot of data points on Harlan. We want to go back all the way, so we'll know more about him. Some people suggest he is sort of, if you think about judicial self-restraint as a severe reluctance to strike down or invalidate legislative action, some people suggest Harlan was the last of the true restrainists. I think O'Connor and Kennedy, it clearly goes to their role as the center justices. So they're making majorities either way. And they're the sort where you see they're very high in terms of majoritarian behavior when the court strikes. They're almost always in the majority. So that's why I think they don't look as ideological. So, get justices who are going to position themselves close to the center of the court, and you won't see those underlying ideological patterns.
We have a question from Professor Sharkey.
Yeah, so this is also for Lee Epstein. Maybe the Charles Friedian critique of the kind of data that you showed might be that your terms like conservative law, liberal law, just mask more than they reveal. And given that, I just wanted to give you an invitation. I was curious if you could say a little more about the types of laws, whether you were looking at a comprehensive set. And then actually my interest would be too in, you showed them kind of quickly, but in the graphs where some of the percentages, were slightly different, like 0.4 on one, 0.6 on another. If you've investigated the instances where the justices do something out of typecast, so not the Kennedys, O'Connors, but the ones that you say are basically ideologues, whether you've looked at the types of laws and whether they're more of the sort of significant ones, whether they're more less controversially categorized as conservative versus liberal, et cetera.
Well, I didn't want to show all of the boring coefficients from all of the boring models that we did, but let me take the last part first, which is there's lots of things that affect why justices invalidate or don't federal, state, and local statutes other than ideology. So most obviously, in the data I showed you, we combined constitutional review of federal, state, and local laws. If you take into account those various kinds of laws, just as you would predict, the court's a lot more likely to strike a federal law. That's just one example of that. There's certain kinds of laws that are more in the civil liberties category as opposed to the economic category. They're more likely to strike. So there's lots of features I didn't reveal beside ideology that explain invalidations. It just is, and I went into this sort of neutral, but it just is very hard to wipe out that ideological effect. That's my only point. Defining what liberal and conservative mean, that's always a question. Those are concepts. We have to define them in some way. We use pretty standard political science definitions. So a law that restricts abortion rights in some way would be a law that had a conservative, substantive policy embedded in it. A law that funded abortions would be one that had a liberal, substantive policy embedded in it. But, we just follow pretty standard approaches. We would argue, I think, we could all argue about those definitions in certain kinds of cases. I don't think they work as well as in other cases. But I think on balance, and remember, we're doing a big number thing here. On balance, I think we would agree with a lot of those definitions. We would fight on the margins on some. We haven't investigated yet precisely the questions you're asking about particular justices, particular factors, and we hope to do that.
We have a question over here.
Hi, Professor Epstein. This is directed to you mostly. I noticed that Professor Pursley said that not all overrulings are created equal, and I was wondering if that would, if you took that into account in your data, would the numbers look different?
Yeah, this is always a really important issue, is we tend to think that not all cases and not all laws are created equal. So how do you wait for the importance of the case, of the law? And we have, I can talk about particular measures that one would use to do that. We haven't embedded those measures in our models yet. We will. But I will say that there is a kind of work like ours, is somewhat different, that did try to take into account the nature of the legislation. Was it really weighty, important legislation? And they really didn't find much of an effect. But that would be the next step in our analysis.
Can I say one thing on that, which is that, because I don't want my comment to be viewed necessarily as a critique. With all of these types of empirical studies of judicial behavior, I think people want to extrapolate conclusions beyond what the authors want to say. And so something like this is, if you think Citizens United is a very big decision, right? The fact that the Roberts Court may have been deferential across a lot of other areas, doesn't then sort of silence your critique about their activism or the fact that they might be aggressive in this realm. But if you are trying to make the argument, well, what's the propensity of the Roberts Court as compared to other courts in the average case to strike down laws, then you have the information.
Right. I think it's really important not to extrapolate too much to particular cases based on these large N studies. They are trying to draw a bigger, sort of a general picture, but these are the important guys because they're the detail guys, right?
Okay, so I'm hoping things are about to get very, very interesting. Charles Freed.
Well, Lee did invite me to respond.
Bring it on. Bring it on.
Actually, the challenge he raised is so easy to answer that I'm not going to bother with it.
I'm writing that down to use.
There's something deeper that you were saying, and it came to mind as you were talking about Harlan, who I did reference in my talk, And I'm thinking, here's this very conservative justice, and I'm thinking of two of his decisions. One, a dissent in Poe v. Ullman, which actually is what got the whole substantive due process thing and Griswold and Roe v. Wade and so on going. Happened to be the year I was his law clerk. And the other one, I think, is Cohen against California. One man's obscenity is another man's lyric. Well, you know, at that point, how do you explain those within your system? And I would suggest there are two different ways of explaining it. One could, as your talk, try and get more and more and more data points. Who were the lawyers? What was the opinion below? So on and so forth. And you might do it that. I suggest a much simpler way. Was the argument a good one? And is the judge in paradise or is he in the fire?
I want you to be able to measure paradise, though, Leah. That I think.
I have to admit, I have to think about that one. Yeah. Well, I will take both of those suggestions. Very excellent suggestions. Thank you.
Professor Charles has a question for Charles Fried.
Charles, so if I may, what is your response to the ideological finding? That is, I didn't appreciate that particular element, and I'm just curious. That ideology matters.
My problem is with the term ideology. Ideology is a term that is used by political scientists as a substitute for good or bad reasoning or good or bad arguments, as if the arguments and the reasoning didn't matter, something else mattered. And of course, the more closely you parse the concept of ideology, as I think Lee was starting to do, the closer you come to actually talking about the merits and the substance. And that's what I think we ought to be doing.
Thank you.
Okay, we have a question over here.
Yes, I just had a quick question for Professor Hazen about the invitations that you were describing, where a court can kind of basically say, well, if you come back later and do this, maybe I can get you a few votes. And I was just wondering if you wanted to comment on how appropriate you think that is one way or the other. Is it something that should be done a lot? Do you think it's something that people should try, or that the courts should try to, all courts maybe should try to stay away from? You're sort of giving away the game, as it were.
Well, I know that invitations to Congress, which Justice Ginsburg did, she was attacked for doing that. She was attacked by people on the right who didn't like that. And I think that some people think that Justice Alito's time bomb, he's being attacked, just like we're seeing, I don't know if you saw in today's paper, 94 Democratic senators have signed a 94 Democratic.
Wow, was there an election?
94 Democratic members of Congress signed a letter that Justice Thomas should recuse himself from the health care case because his wife is now working as a lobbyist and might have connections to health care. Senator Hatch, who's a Republican, one of the 94 Republicans, Senator Hatch put out a release saying that Justice Kagan should recuse herself from the health care cases because she was in the Justice Department when health care was passed. It's very hard for me to make normative judgments. What I'm seeing is a pattern, which is that if you don't like where you think the justice is going to vote, you find a way not on the merits of the decision to try and knock them out. And I think that maybe invitations and time bombs are ways that justices do things below the radar and try and fight back in some ways. And I do see the court justices as trying to shape the law in the direction that they like, and it's really not much different than what they do as a majority when they overturn a case or extend a case. It's just how one justice can act when there's not a complete majority to go in that direction.
Is there a question over here?
Thank you very much. Former Justice Stevens has talked about the contentiousness of the nominations process. He's compared different periods of history to the current period. And so my question has to do with ideology in that context, but I'm afraid to use that term now, so I'll just say judicial philosophy instead. And so the question is whether or not, given the current process that's used in nominations, whether it's more easy to predict what a justice would do than it was in a former period. You know, we had a lot of surprises, particularly Eisenhower appointments were supposedly turned out to be surprises. And anyone can address that.
No more suitors, right? that's the mantra. I think that's probably right. You know, that the last 4 appointees are more predictable than some others. But you know, I think most of the political science on this says that justices tend to be, they tend to be predictable. You know, I think that now with the interest group politics in confirmations and the Supreme Court appointments process, that I think that there's much more risk aversion than there may have been historically, but it's an empirical question.
What the data tend to show is you can do a pretty good job predicting how judges are going to vote for like the first 10 years. And then after 10 years, things become more unpredictable for a certain set of justices. And those justices, the further away they were from D.C., the more unpredictable they get. And I think the case is that when a president makes an inside the Beltway appointment, they tend to have more information about the justice. So if you look at the last couple of appointments, the one justice we might expect to drift in over the next decade or so is Sonia Sotomayor. So that is less of an inside the Beltway appointment than, say, Elena Kagan or John Roberts. So that's what the data tend to show.
Because Sotomayor is from the heartland of the South Bronx.
Yeah.
You know.
It's a relative distance, right? You
Absolutely.
know, we're talking what? How many stops on the Acela Express for most of these people?
Might as well be Kansas.
Exactly.
Okay, so with that, I'd like to thank the panelists for a great session and invite you all to the reception outside. Thanks.